All right, welcome back, everybody. Today is episode 12 of Law with Darren. Last week, we covered Rhode Island family law, and specifically the question of, can my ex move out of the state and take the kid with me? Today, I'll be covering the Massachusetts version of that. So, getting right into it. In Massachusetts, one of the cases I found that really covered a lot of the issues I'll be discussing today is the case of Rosenwasser versus Rosenwasser, 89 Mass. Appeals Court 577. So, to get right to the point, in Massachusetts, if you have a custody agreement and you and your spouse live in Mass and the order says that the kid has to stay in Mass or that you guys need permission, one spouse would need permission to move the kid out of the state, Mass applies something known as the two-pronged real advantage test. And here's the test. So, to satisfy the, quote, real advantage test, the custodial parent must demonstrate the soundness of the reason for moving and the absence of a motive to deprive the non-custodial parent of reasonable visitation. So, that's essentially the test. Now, the first prong of that test is the best interest of the child, because as I've explained, when it comes to family court, we only care about the kids, right? What's best for them? The best interest of the child is always going to win out. So, a couple of the factors here that go into weighing the best interest of the child. The first one being the child's quality of life in terms of where they are now versus ultimately where the parent that wants to take them, what kind of quality of life would that kid have there? The other leg is the child's relationship with the other parent, the one who's not seeking to remove the child from the state of Massachusetts. Number 3, the child's emotional, physical, and developmental needs. There's a lot that goes into that one. Number 4, the interests of both parents. And number 5, reasonable alternative parenting plan. Now, that all falls within the prong of what's in the best interest of the child. And lastly, once the best interest of the child has been weighed, the judge then has to balance the advantage of the real advantage that the parent who is seeking to move the child has versus those best interests that I had discussed. So these cases can get really, really messy. So that's the test. I'm going to go into a case right now for you guys. So if you want to keep listening, absolutely, I'd love to walk you through. So in the Rosenwasser case, and I'll read to you guys. The parties married in March 1990 and lived together in Florida until 1997, when they relocated to Mass. The father grew up in Florida, and much of his extended family still lives there. The mother's parents, who are Canadian, also live in Florida, approximately 5 months out of the year. The father is one of the 3 partners in a small law firm that has offices in Florida, Mass, and Kentucky. Each partner operates primarily out of one office and is responsible for bringing in his own business and profits. The father works primarily out of Newton, Mass, and also works out of an office in Boca Raton, Florida, approximately one week per month. The dad also employs one associate in the Newton office, as well as 2 paralegals and a bookkeeper. So, after nearly 20 years of marriage, unfortunately, the parties separated in February 2010. Oddly enough, shortly thereafter, in May 2010, so only 3 months later, the mother gave birth to the parties' only child. In October 2011, so about a year and a half later, the parties were divorced pursuant to a separation agreement. The separation agreement provided the mom with primary physical custody of the child and the father with, and I quote, liberal parenting time, whatever that means. The separation agreement required the father, as the family's sole wage earner, to pay the mother base unallocated family support of $42,000 per year and additional support, which is based upon a percentage of his earnings between $120,000 and $350,000. So, now here's where it gets a little messy. And these are the court's words. It is undisputed that almost immediately after the divorce, the mother became unable to care for the child due to her ongoing mental health issues. It's very sad, including depression and anxiety. The father quickly took over as the child's primary caretaker while continuing to operate his law practice. The child was enrolled in full-time daycare, and the father also used paid babysitters to provide additional child care coverage during non-daycare hours. Because the mother was unable to care for the child for extended periods of time, the father took the child with him on his monthly business trips to Florida. In February 2012, the father filed a modification complaint seeking primary physical custody and a reduction in his support payments to reflect the reality of the changed parenting arrangement. In August 2012, the father was permitted to amend his complaint to include a request to remove the child to Florida on the basis that he, quote, has no support system in Mass to assist him with the child. And his family, including his child's grandparents and friends, live in Florida. His law firm's main office, partners, and staff are in Florida, and he would have more income available for the child if he were to move to Florida and operate solely out of the Boca Raton office, as there is a considerable cost in maintaining offices in both states. So, in August 2013, the parties entered a partial modification agreement, which provided the father with primary physical custody and gave the mom more parenting time. The remaining issues, including the father's request for removal, to remove the child to Florida, and reduce support payments, went to trial. During the 5-day trial, which began in August 2013, the judge heard testimony from the father, the mother's parents, and the mother's court-appointed guardian ad litem. Not sure why the mom needed a guardian ad litem. That's never a good sign. Guardian ad litem is someone who's kind of represents an individual entity. In this case, the mom. Usually they're for kids, so I don't know why the mom needs it. She must have really been in a bad spot. The mother did not testify. Also a bad sign. It is undisputed that from the time of the divorce in October 2011 until the start of the modification trial in August 2013, the mother missed the majority of her parenting time. However, during the 5-month period in which the trial was pending, the mother was able to exercise all of her scheduled parenting time. Well, good for you, I guess. You're able to show up when you need to. On July 22nd, 2014, the Probate and Family Court entered a modification judgment which, among other things, denied the father's removal request and substantially reduced his support obligation. So basically, the dad sued to, have the ability to remove the child to Florida, and the family court judge ruled against him and decided that that wasn't going to fly. And so the court in this case, goes into how and this is the appeals court. The appeals court in this case looks at how the trial judge applied the two-prong real advantage test, and ultimately, goes through all the factors, looking at the child's quality of life, the child's relationship with the other parent, the child's emotional, physical, and developmental needs, the interests of both parents, and the reasonable alternative parenting plan. And ultimately, the appeals court rules sort of in the dad's favor. What the appeals court does is they say that the trial judge made a mistake in weighing too heavily upon the mother's interest in seeing her child, which is actually not the way you're supposed to apply that best interest of the child test. Obviously, the mother's interest in a child's interest in seeing their parent is one small factor, but you really need to focus that analysis as an attorney and a judge on the child, what works best for the child. And the appeals court in this case felt as though that the trial judge focused too heavily on the mom's interest in denying the dad's motion to remove the child from Massachusetts. So the appeals court basically remands the case back down to the trial judge to specifically make a ruling and make findings upon the best interest of the child and not focus so heavily on what is in the best interest of the mom. So I don't have the answer to this question. I don't know if this poor dad ended up ever getting his child. And I feel bad for the mom too, obviously, but not that, my feelings are relevant on this issue. So guys, that's the way that Massachusetts courts apply the law. So if you have a child in Massachusetts, And if you're looking to remove that child and you already have a support order or a custody order in place, an agreement where the child has to stay in Massachusetts, and you want to move that child, you got a pretty tough burden. In this case, obviously, the deck was really stacked, and I believe in the favor of the dad to let him officially relocate the child to Mass. I'll try to find another case maybe where there's a little more of a fight going on here, maybe a little more of an equal fight. So either way, I hope you guys enjoyed the episode, enjoyed the video. Feel free to like, comment, and subscribe if you have any questions. And until next time, be safe, be well, and take care of yourselves.